labor certification process. A permanent labor certification issued by the Department of Labor, the DOL, allows an employer to hire a foreign worker to work permanently in the United States. In most instances, before the U.S. employer can submit an immigration petition to the U.S. Citizenship and Immigration Services, the employer must obtain an approved labor certification from the DOL's Employment and Training Administration. The DOL must certify to the USCIS that there are no qualified U.S. workers who are able, willing, qualified, and available to accept the job at the prevailing wage for that occupation in the area of intended employment, and that the employment of the alien will not adversely affect the wages, working conditions of similarly employed U.S. workers. Let's look at the PERM labor certification process. To improve the operations of the Permanent Labor Certification Program, ETA published a final regulation on December 27, 2004, which required the implementation of a new, re-engineered Permanent Labor Certification Program by March 28, 2005. The PERM system, i.e. the Program Electronic Review Management System, is a program developed by the Department of Labor to replace the then existing employment-based labor certification application. Let's look at how PERM works. The PERM procedures have been designed to expedite the labor certification process. It eliminated the two methods of processing in place at the time, the regular and the RIR, or reduction and recruitment process. PERM labor certification process uses an automated computer system to scan attestation forms filed by the employers regarding their compliance with all regulatory requirements. However, it is supposed to be a strict and rule-based system, requiring less paperwork and cutting down on the time and formalities of collection of documents. Are all applications covered under PERM? The DOL PERM regulation came into effect from March 28, 2005 and is applicable to all applications filed on or after that date. As of March 28, 2005, applications using the old Form ETA 750AB are no longer accepted. The new applications, Form ETA 9089, are needed to be filed under PERM labor cert process at the appropriate National Processing Center, only if an employer chose to withdraw an earlier application and refile the application for the identical job opportunity under the refile provisions of PERM, no longer applicable. Would a previously filed application be processed under the PERM regulation? Since the backlog of labor certification applications has been cleared, the ETA 750 can no longer be used for any permanent labor certification. Let's look at filing the application. An employer must complete an application for permanent employment certification, that Form 9089. The application describes in detail the job duties, educational requirements, training, experience, and other special capabilities the employee must possess to do the work, and a statement of the prospective immigrant's qualification. Applications submitted by mail must contain original signatures. Applications filed electronically must, upon receipt of the labor certification issued by ETA, be signed immediately by the employer, alien, and preparer, if applicable, in order to be valid. Prevailing wage determination. Prior to filing the ETA Form 9089, the employer must request a prevailing wage determination through the Department of Labor's new iCert portal. The employer is required to include on the Form 9089 the iCert provided information. This is the prevailing wage tracking number, the SOC or ONET codes, the occupational title, the skill level, the wage source, the determination date, and the expiration date. Let's now look at the recruitment steps to be completed before filing. The PERM labor certification process requires employers to attest, in addition to a number of other conditions of employment, to having conducted recruitment prior to filing the labor cert application. The employer must recruit under the standards for professional occupations set forth in the regulations if the occupation is on the list of occupations published in Appendix A of the preamble to the final PERM regulation. This is for anything with a bachelor's or higher degree is a customary requirement. For all other occupations not normally requiring a bachelor's or higher degree, Employers can simply recruit under the recruitments for non-professional occupations. Although the occupation involved in a labor certification application may be a non-professional occupation, the regulations do not prohibit employers from conducting more recruitment than is specified for such occupations. The employer must categorize the lawful job-related reasons for rejection of U.S. applicants and provide the number of U.S. applicants rejected for each category. The recruitment report does not have to identify the individual U.S. workers who applied for that job opportunity. All right, let's look at a case. Yumi, a Japanese national, trained as a classical architect, has just started with a firm in Seattle. The firm has unsuccessfully been trying to fill his position for over 8 months, including running ads in the local newspapers and in architectural trade journals. The partners are impressed with her work already, beyond what they expected. At their most recent meeting, they decided to pursue permanent residence for her. After doing some research, they find that they must complete a labor certification for her before they can file with USCIS. The rules for recruitment are very specific. However, some of the previous recruitment efforts should be able to be used. You will have to determine which efforts can be used and which cannot. When looking through the files that they bring you, you are thankful that they saved all the resumes that have been submitted throughout the process, and that the interviewers had taken very good notes on why each applicant was not qualified. You start putting together a list of the remaining requirements that have to be fulfilled. Let's look at filing the application now. The employer has the option of filing an application electronically using the web-based forms and instructions or by mail. However, the Department of Labor recommends that employers file electronically. Not only is electronic filing by its nature faster, but it also will ensure that the employer has provided all required information. An electronic application cannot be submitted if the required fields are not completed. All right, we've been through a quick overview of the PERM process. Let's do a recap. PERM was designed to streamline the labor certification process and reduce the processing times. DOL anticipates adjudication of most cases filed under the PERM labor certification to be within 45 to 60 days, unless there is a DOL audit and the employer is required to submit additional information, or in certain cases which may be subjected to supervised recruitment. Thus, it is important that all the statutory guidelines are complied with before filing an application under PERM. You have to obtain the Green Card labor certification without any delay. If you have any questions about the PERM labor certification process or need assistance in filing, contact Visa Pro Immigration Attorney. We will be happy to help you.